Otherwise, then 148(1) is not justified. In the case of 143(1) cases, suppose it is 143(3), and that is not beyond 4 years, within 4 years. Bombay High Court recently considered Usha International and all, then said change of opinion. Already all the material was given. That was with respect to gifts. Same, all the material was there. No further was there. No further information was provided. The reasons recorded. You have given everything. It seems that testing officer is not applied to his mind. So we will. I am issuing 148(1) because there is a escapement of income. In such a situation, Bombay High Court has that. See, and the assessment order was completely silent about this entirely. The SC provided all the details. What was the notice issued and one in response to that what he has, the material he has given. That just because he has not said anything in the assessment order, it doesn't mean that he has not applied his mind. If he chooses, he issues a notice, all the material comes to him and he chooses not to comment in the assessment order, it means that he has applied his mind and he doesn't want to proceed further and accept the contention of the SSC. So subsequently on the same material, if you want to issue 148(1) notice within 4 years, that is change of opinion, and they say that Kelvinator, Supreme Court, Usha International, all that come. So the Bombay High Court is Aditya Arvind Kapoor I have given, it's not a reported case. If you want the copy of the order, Ketan will provide. And this one more aspect of that, whether the reasons recorded.
Sir, may I?
Yes.
143, assessment is completed. At that time, everything in detail is provided, including the sales and purchase details. Now, they got the information from the department, salary department, stating that this is the purchase made by you, it's like this. And I reason to believe.
Yes.
Whether it's a valid down.
What they have recorded in the reasons recorded. What I will do, your question is a very nice question, and Ripple has also come because Ripple is dealing with their suspicious dealers. So that part I will leave it for him. I will go only to the reasons recorded. Suppose reasons recorded says that, you see, this is the information, all the same information, we have got a reason to believe looking into the record that this seems to be a bogus purchases. Then definitely you have got a good case. But they say that subsequently the name is displayed on the sales tax website and all that information is there and they have got some other information, then they are justified. That is not change of opinion, that is they have got some additional information. Suppose during the course of the assessment this issue was raised, your name is shown in the sales tax site and these are the information I have got, so why it is not bogus? For that you have responded and you have given all the details. And subsequently, with the same material, he comes back to you say that is the reason, then he can change of opinion. That can be changed. So, but anyway, this issue, you can ask, Ripple has come, he has prepared very well, he will answer all these questions.
Regarding the statement made on oath,
yes,
before any authority,
yes,
government authority, can be a ground for government to rely on that statement. Which is without any evidence before that authority, only simply under the threat or influence or anything. They made it, I have not done this.
Just only one clarification can you give me? The statement is being used in whose proceedings?
Against the SSC.
When SSC's statement and being used in the SSC's own case.
Yeah. No. The statement is made by some third party. Who is a bogus man.
Yes.
Supposed to be a bogus man.
Huh.
But his made statement, which is we have got evidence that having the purchase with us. Now he makes the statement before the officer that I made this, I have not made this since. But the officer do not collect any evidence except his own statement.
See, one clear-cut answer is that a third party statement cannot be used against you without you being provided an opportunity to cross-examine him. But practically, one I think I will say, because here, as I mentioned in the beginning of this law, as far as the evidence law is concerned, is settled. We are not, and see, Actually, I wanted to put this disclaimer in the beginning. So I don't know. Ketan said that somebody is going to educate. I have come here to learn. If he is educating it, I am happy with that. But as far as I am concerned, I am not a person who is going to educate anything. I am learning it. What you saying is, information whatever is there in that statement can be used against you, but after you being provided an opportunity to cross-examine. And this, all this, whatever your queries you have got with respect to this bogus purchases, I know that all these issues will come up, but I have been asked not to deal with that because people's jurisdiction is there, so I can't.
On the issue of oath,
Okay, I will answer.
I think, may I request all of you to please let him complete, and then we will have a 5 minutes question answer session. Please.
Now, all other aspects of reopening beyond 4 years, this is also I would like to deal with, not in a very detailed manner, only within 4 years I explain in what circumstances change of opinion and all these things will be valid. Now beyond 4 years, it totally changes. Then the assessing officer will have to make a specific reason, in the reasons recorded specifically mentioned. On this basis, I say that you have failed to make a true and full disclosure. I am issuing 148(1) notice. Suppose reasons recorded do not do that, then he can't issue a 148(1) notice. Wherever this is not done, do it. But here, this any information and enhancement of this knowledge with respect to reopening and all, you will get so much material. One or two practical things which usually in my day-to-day practice I realize is, certain things be very careful. The moment you come to the reasons recorded, you file objections with each and every point raised in the reasons recorded. Don't miss out on anything. Because I have given case laws where Bombay High Court says that once reasons are recorded, they can't be changed in any manner subsequently. They can't improve upon the reasons recorded by way of an affidavit or anything. Reasons recorded are the jurisdictional trigger point, they have to remain as it is. Similar is the situation with respect to objections raised also. You don't object to a particular point. While filing in a petition or if you are filing a challenging an appeal, then you come up with this, this issue was not, no. Whether that objection you have taken or not, when you were objecting to reasons recorded. So each and every point which he is raising in the reasons recorded, you have to object, because then you will not get an opportunity to improve upon. One of the very cases, I was sitting in the courtroom, I saw the SSC had an excellent case. Court was completely, bench was with the SSC completely. But they realized, the counsel pointed out that this is not the objection they have ever raised in the objections. They said, is it so? Then they looked into the objections. That point was missing. That was taken only in the writ petition. Court was not with the SSC. Said, no. We will not give you an opportunity. When assessing officer doesn't have an opportunity to improve upon the reasons recorded, then you can't come up with a objection which was originally you have never taken, and for that, because you come to the court when the objections are disposed of. I mean that objections he has mentioned, while disposing of, he mentioned that he have objected to everything, but this particular point you have not objected. So I will proceed with the assessment with respect to that. So the court said that yes, we will not going to. So this is a very important point. Yes. Now, valuation officer, I have given the information. That's for the sake of information I have given. Whether that can be a report, can be a basis. The contrary views are there. And with this, I conclude. I thank Ketan and all chamber for giving me this opportunity, for sharing my information with you. If I have missed out on something, other speakers are there more eminent, so you can catch up with them. Thank you very much.
we'll have a very short question, very short, because we have got the next session also, which is very interesting. A few questions can be still addressed, please.
Sir, in 148 notice for Hawala dealer, can you go beyond the Hawala dealer's point for other transactions also?
See, if suppose he makes an addition in Hawala dealer's case, then he finds out during the course of the assessment proceeding something more, he can very well travel. But suppose in the Hawala cases he is not able to find anything, in your cases he can't do it, then he can't travel to other issues. For that I have given Jet Airways case, Bombay High Court is there. I have in my presentation I have given the case law. That's what it is. But after amendment, post amendment, if there is an addition or disallowance with respect to the specific issue which is been recorded, reasons recorded, you can very well go beyond that. If you find something during the course of the assessment.
Sir,
Yes.
in the section 148, it is given that the result should be recorded. It means that it should be given to the assessee on his demand. But under section 153C, it is recorded as satisfaction. And AO strictly refuses to give the satisfaction recorded because he says that this satisfaction is not the reasons. Is it valid?
See, is a distinction in two sections, satisfaction. Instead of comparing it with, 148.1, you think of the 153C with 158BD. So their satisfaction, once he has recorded, because unless until there is you are a third party, you are not the search party, you are a other party. So unless and until you know the reason why he has come, so you may not be in a position to do it. But I think there are certain case laws now which say that they have provide satisfaction.
Recently, just in the last week, they have refused. And one more thing is that issuance of notice under section 153C, what is the reasonable time? Because one raid was made, I will give you the dates with due respect. 20th April 2010, there was a raid on my client. His assessment was completed on March 13 under 153A. Then his wife's case was, his material was transferred during the course of appeals. I am fighting his appeals under 153A, challenge to the CIT appeals Nasik. Now 153C notice has come on 9th May 2014. Actual raid was on 20th April 2010. So can it be possible that is reasonable time of 18 months?
I think under 158BD, 115BD, I think there also a specific time limit was not provided. So there are case laws under that. 153C specifically, I have not made this research, so I am not able to make a statement. But if it is beyond a reasonable period, you can very well try.
Yeah, but he is not at all answering, and just in the last week only he refused me in writing that I am not going to give the satisfaction even.
You under what I am saying is 292BB you try to overcome by putting everything under protest. But this position you can if he is not giving at this point of time, at the time of appeal and all, you will have to provide. You will have to arm yourself at that point of time. I think as far as satisfaction is there, and unless and until you know the reason and with respect to what he wants to go, because 153C open up the entire thing. So now question comes he can deal with everything or he has to limit himself to the seized material which is for satisfaction is there. So that issue will come up. So you need to have the satisfaction.
The last question.
In case the reassessment proceedings get passed at the next level and the time is still left for reassessment, can the assessing officer reopen the case?
For what reason it has been flashed?
For the notice. The notice is
because
given.
reasons were not properly recorded.
Right.
So then he records afresh
Right.
reasons,
Right.
and that he overcomes all the, he is properly doing it, well and good. But there is a, you can't, there is no establishment, once he has committed a mistake, you can't stop it.
Okay. So also, like this 130, supposing I am not getting a chance to cross-examine the material what he has got, whether I can go directly to High Court or I have to again go to appellate proceeding.
See, going to High Court it's a very subjective thing, because Article 226 of the Constitution of India is a very, extraordinary power given to the High Court. Judicial review in the case of breach of any rights of the assessor or any person. Then you will have to show that this is going to cause, then only you should go. And especially in the cases of where bogus purchase and all are involved, come to the normal course. Article 226 will determine the issue completely, either this way or that way. That's a little risky proposition. Unless and until you have got a very strong case, it depends upon the case to case.
Yes.
So, generally what we do after receiving 148, we file a return, we ask for reason and we raise our objection. So my question is, what is the reasonable time to raise our objection? And second question is, can the AO drop the proceeding under section 148 after, if my objection is, or only remedy is to file writ against? Because whatever good your case is, AO never accepts it, he always rejects it. So, what remedy?
No. Usually, once the 148(1) is issued, reasons are recorded, you file your, because that case law which I have given, GK and right shot says that casting officer is satisfied, he can very well drop. He has got the power. They don't do it as a different issue. But going to writ petition at that stage, after he has disposed of the objection, that is the time when you have to take a call whether you want to go. Because there also Bombay High Court decision is there, which says that after disposing of the objections, assessing officer will give 4 weeks time to the SSC to consider whether he wants to further challenge or not. Justice Chandrachud's decision is that 4 weeks time has to be given. If he wants to challenge, he can very well challenge. That's what.
And so the reasonable time to raise objection after?
Right. Reasonable time objection I given a Gujarat High Court decision which says 60 days. According to me, 60
After
days
receipt of reasons.
after receipt of the reasons. First thing, you will have to immediately respond, because 148(1) has got a time lag. Is that within particular period you have to file returns. So once you have to respond within the time. Once you go beyond the time, though it has not been legally tested, nobody has questioned, but suppose according to me legally they have given 30 days time and you respond after 45 days, I think then whatever you are doing, you may not have any right to challenge it. You will lose that.
Thank you, Gopal sir, for a very elaborate discussion. You have taken us through a lot of legal concepts, and a well-deserved vote of thanks is due. But before that, one announcement: we will not have any break in between. There will be just a change of dais after the session is over, and we will have the next session will immediately start. And now I will request Rahul Haqqani to propose a well-deserved vote of thanks. But before Rahul proposes vote of thanks, I would like to thank Rahul himself for giving a wonderful material, and also Advocate Jitendra Singh in his absence for giving a wonderful material which we have all got with us. And now I will request Rahul, please.
Respected President of the Chamber, R.S. Savla, Chairman of the Direct Tax Committee, Ketan Majani, past President, friends, and the focal point of our today's presentation, Advocate K. Gopal. I must say we had a very good choice in having Mr. K. Gopal as the opening batsman to kickstart our today's full-day seminar. And I am naturally excited because he belongs to the same chamber to which I am associated, that is Dr. K. Shivram. I must say that the law of evidence is a very, very dry subject, but he naturally infused a lot of life and made it very juicy by incorporating anecdotes, his own personal professional experiences, and giving very practical examples. He also articulated very eloquently the nuances of the law of evidences and its interlinking with the income tax law, with which we deal every day in and out. He also drew a very thin line of distinction between confessions, concessions, admissions, and also explained to us that as a professional, we should not indulge in these concessions but ensure that the assessee or the client does it. Because even I, as he explained, I have come across professionals giving concessions and then landing in some kind of a problem. Lastly, his instructions on drafting of affidavits and also the letters where assessors give up their claims so that they are not saddled with penalties is going to be very helpful to us. Therefore, I take it as a great privilege to dedicate a vote of thanks to Advocate K. Gopal on behalf of the Chamber and everyone who is present here. Thank you.